Now, there is another question, but I'm not sure. You're just starting to talk about it with the alternate decision making, so
Yeah,
I might just hold off on.
let me go into that. So that sort of leads us greatly into this next area of alternate decision making. As I said, there's this presumption that when you turn 19, you're capable of making your own decisions. But as we all know, this is not necessarily true, either due to disability or aging, disease, or accident. And some people never acquire the ability to make their own decisions, whereas others might actually have the ability to lose it. So we have a number of vehicles available in our province around alternate decision making. And I just want to highlight them just so that families are aware of these options. Some of these relate to people with disabilities, and others relate to the actual parents themselves, the individuals actually designing these plans. Comityship is really a last resort option around alternate decision making. And effectively, what it is the court making a decision that an individual has lost capacity and is not able to make decisions about either their health care, or we call that their person, or their financial or legal affairs. So it's a very drastic decision, and it's a last resort option for many. It's also a very expensive process. Comityship is effectively a court application to a judge to have that judge make that appointment. And so the cost can be excessive, um, very common in the lower mainland for up to $10,000 to be spent on comityship. I know that this is a reoccurring problem and thought process for many families with children aging out into the age of 19 and families thinking that they need comityship to be able to carry on control and guardianship for what there was their minor children. And I say guardianship at the age of 19 and comityship should only be pursued if it's absolutely necessary. And so it's not always necessary, and we live in a province where there are some other options, and I'll touch on those a little bit as well. The other downside of comityship is that you don't have choice in who's going to be a committee. Somebody's got to apply to be committee, and it may not be who you want to make decisions about yourself. So we want to avoid committeeship as a last resort.
It's also one thing that we've heard is that once comityship has been put in place, it's almost impossible to revoke or to remove that.
Challenging, yes, or to change it if you
Right.
need a new committee, or circumstances arise. There's also some significant vetting by the public guardian and trustee that is required, and so there's not only the upfront costs of obtaining a comityship order, but there's also the administrative responsibility that will continue for the indefinite future. Um, so one way around avoiding comityship is to ensure that you've got an enduring power of attorney. And this is a living document. And so I want to just distinguish a power of attorney from a will, whereas a will is a death document. It only takes effect when you die. A power of attorney is only in effect while you're alive, and it dies when you die. But what it does is it allows you to appoint someone that you trust to make legal and financial decisions on your behalf if you lose capacity. Much like a will, though, the test for capacity is very, very high. So you need to understand what a power of attorney is. You need to understand what it means to delegate to an attorney. So this may not be available to our son or daughter that might have capacity issues, but for a husband and wife, having a power of attorney is a very important vehicle because what it does is it ensures that you've got an insurance policy in place on let's say, assets that are held jointly. So an example is a property. So many families have husbands and wives that jointly own their home. But what we forget about is, well, what happens if one of those spouses loses capacity or needs medical attention, needs to go into a care facility? Because that property is held in joint tenancy, only those joint tenants are able to actually manage that property, refinance it, sell it. So by not having a power of attorney, you now have basically frozen that property if one of the spouses became incapacitated in a jointly held asset, and you might be left to comityship. The power of attorney allows you to appoint another person to manage your financial and legal affairs if you lose capacity and therefore deal with those jointly held assets.